Oluvannyuma lw'endagaano y'okwewozaako kuno okuteesaganya wakati wa Ssaabawabi wa gavumenti n'abavunaana bannansi ba America okuli Mackenzie Spencer ne Nicholas Spencer kiyite plea bargain agreement, bano balabiseeko ku kkooti y'ensi yonna ewozesa emisango gy'abakalintalo okwanukula ku misango egy'okutulugunya omwana ssaako n'okumulagajjalira. Abafumbo bano bagguddwako emisango 6 egy'okuyisa mu bukambwe omwana, okutyoboola n'okulagajjalira omwana, okubeera mu Uganda mu ngeri emenya amateeka n'emisango emirala. Bano emisango gyonna bagikkiriza era omulamuzi Isaac Omuhangi n'agibasingisa.
We have a total of 6 counts, and count 1 is the statement of offense for that count is cruel, inhuman, or degrading treatment or punishment contrary to sections 7 subsection 1 of the Prevention and Prohibition of Torture Act 2012. And this charge is against only one of you, and that is against only Mackenzie Mathis. So the particulars of that offense are that you, Mackenzie Mathis Spencer, between December 2020 and December 2022 at Naguru in Kampala district, you intentionally inflicted physical or mental pain or suffering on John Kaima Spencer, male, juvenile, aged 10 years, by isolating him in a separate room and away from other children, withdrawing him from school, making him sleep on a wooden slab without a mattress, repeatedly keeping him naked and making him sit in one position on cold tiles with his legs crossed and folded, making him feed on frozen food, while constantly monitoring him under CCTV surveillance 24/7 as punishment for his misbehavior or under the pretext of instilling discipline. Ms. Mackenzie Mathis, have you heard the charge against you? Have you understood? And what do you say about it? Is it true? Is it not? Is it true? Is it true? Okay, a plea of guilty is entered on count 1 for you, Ms. Mackenzie. Count 2 is a charge of neglect, child neglect, contrary to sections 157 and 22 of the Penal Code Act, Cap 120. And this charge is against only you, Mr. Nicholas Scott Spencer. And the allegation is that you, Nicholas Scott Spencer, between December 2020 and December 2022, at Naguru in Kampala district, having the lawful care or charge of Kaima John Spencer, a male juvenile aged 10 years, being able to provide the basic needs to a child, you neglected to provide for him sufficient food, clothes, bedding, safe and conducive living environment, thereby injuring his health. Mr. Nicholas Scott, have you heard the charge against you? Have you understood it? And what do you say about it? Is it true? Is it not? Okay, a plea of guilty is also entered for you, Mr. Spencer, on count 2. Count 3 is a charge of unlawful stay in Uganda contrary to section 66H of the Uganda Citizenship and Immigration Control Act, Cap 66. And it is against only you, Ms. Mackenzie, and the particulars are that Mackenzie Mathis Spencer, between 21st September 2022 to December 2022 at Naguru in the Kampala district, you were unlawfully present in Uganda. Have you heard that charge, Ms. Mackenzie? Have you understood it? What do you say about it? Is it true, is it not? Is it true? You have also entered a plea of guilty on that 66, and this is against only you, Mr. Scott. And the particulars are that Nicholas Scott Spencer, between 20th November 2022 to December 2022 at Naguru in the Kampala district, you were unlawfully present in Uganda. Have you heard the charge? Yes. Have you understood it? Is it true or is it not? Count 5 is a charge of employment without a work permit or special pass, contrary to section 59, subsection 2A of the Uganda Citizenship and Immigration Control Act, cap 66, and it is against only you, Ms. Mackenzie, and the particulars are that Ms. Mackenzie Leigh Murphy Spencer, not being a citizen of Uganda, between 21st September 2022 to December 2022 at New Frontiers Technology Consult Limited, you were engaged in employment without a work permit or special pass. Ms. Mackenzie, have you heard the charge? Have you understood it? Is it true? Fix. It is a charge of employment without a work permit or special pass, contrary to section 59, 2A of the Uganda Citizenship and Immigration Control Act, cap 66. It is against only you, Mr. Scott. And the particulars are that Mr. Nicholas Scott Spencer, not being a citizen of Uganda, between 30th of November 2022 to December 2022 at Motive, you were engaged in employment as the lead Motive marketplace at Innovation Village without a work permit or special pass. Mr. Scott, have you heard the charge? Have you understood it? Is it true? Okay.
Oludda oluwabi nga lukulembeddwamu munnamateeka Lilian Omara lulambuliridde kkooti ebimu ku bikwata ku musango guno, omuli okusibiranga omwana mu kisenge enfunda eziwerako ng'ali bwereere, obutamuwa byakwebakako n'ebirala bingi.
2019, the couple applied to the Ginger Probation and Social Welfare Officer in September 2019. The couple applied to Ginger Probation and Social Welfare Officer to foster the victim. I'll not mention the name, my lord. To foster the victim, who was 17 years then. I beg your pardon, who was 7 years then. And 2 other children. Who were under placement at Welcome Home Ministries in Ginger. The application was duly granted. And the couple began fostering the children, the 3. Since then, they lived with the children, first in Ginger district, until February 2020. when they moved to Kampala. And lived with the children at Naguru Hill in Nakawa Division. My Lord, in 2020, the 3 children were enrolled at Dawn Children's School Special Children's Trust. Dawn Children's School Special Children's Trust. And they were studying well. In the year 2022, A1 withdrew the victim from attending school, and this was despite the fact that the school report indicated that he was progressing very well, but with a few incidents that involved fighting another child. In addition to that, my Lord, it transpired that A1 was intentionally inflicting physical or mental pain or suffering on the victim by isolating him in a separate room and away from other children. She also made the victim sleep on a wooden slab without a mattress, repeatedly kept him naked, and made him sit in one position on cold tiles with his legs crossed and folded. She made him feed on frozen food while constantly monitoring him under CCTV surveillance 24/7. She was doing this to her as a punishment for the victim's misbehavior, or that she was instilling victim. I beg your pardon, she was instilling discipline. A1 also instructed the caregiver, Pamela, who was the nanny, on a series of inappropriate punishments to mete out to the victim for different conducts considered inappropriate. My Lord, Ed too was aware of what was happening and how the victim was being mistreated, but he did nothing to intervene or stop the same from happening. Their theory was that all that was happening to the victim was being done in a bid to manage the victim, who they said was suffering from a complex psychiatric disorder, causing him to engage in serious disruptive behaviors like physically harming others and defying parental instructions. My Lord, the accused persons were arrested on the 8th December 2022 upon a complaint from the nanny. Their travel documents were also inspected and taken from them, and it was discovered that their immigration and travel information indicated that their visa or work permit and special pass had expired. The permit had expired on 21st September 2022, and for A2 had expired on 30th November 2022. Yet at this point, the investigation had revealed also that the two were engaged in employment when their work permit had actually expired. They were accordingly indicted as per the indictment before court. My Lord, we do not have any previous criminal record. Yes, my Lord. Yes, my Lord. And I will apply to adopt those aggravating factors.
Oluvannyuma lw'ebyo bye batuuseko mu ndagaano, munnamateeka w'abavunaano David Mpanga ategeezezza nti abavunaano bennyamivu nnyo ku ebyo bye bakola, wabula kkooti n'obutabuusa maaso nti omwana ono yaliko obuzibu.
My Lord, for the accused persons, this is a matter of grave regret. It's a matter of great regret, my Lord. Yes, my Lord. And my Lord, the only way in which it can be properly described is a tragedy. Lord, yes, my Lord. However, I'd like, with your Lordship's leave, to add very briefly. Yes, my Lord, very briefly, the basis upon which each of them plead. My Lord, they've admitted the facts before your Lordship. But for clarity, my Lord, in relation to count 1, it is admitted that the treatment of the victim was degrading. Section 7 of the Prevention and Prohibition of Torture Act, Section 7, subsection 2, my Lord, requires the court to consider the circumstances of the case. And my Lord, the circumstances of this case upon which this plea of guilty was entered is that they had, accused one had a child she was fostering who presented with difficult, exceedingly difficult behavioral problems. My Lord, the fight incident referred to by the prosecution actually involved not a fight, but the victim cutting with a blade a fellow pupil at school, exhibiting no remorse for this, but rather saying he did so to see blood. The victim cut a fellow pupil at school with a blade that was used to sharpen pencils. And when asked why he did it, he said he wanted to see blood. My Lord, this young boy also engaged in similar conduct against himself, self-harm. My Lord, this boy exhibited behavior that is atypical for his age with regards to his toilet habits. He would soil his clothes and soil the bedding. And my Lord intentionally, on other occasions, soil his room. And this was a room he shared with his foster siblings. Lastly, my Lord, in relation to his behavior, he was very defiant of parental instructions. We do not say these things, my Lord, to blame the victim, but my Lord, to explain the circumstance that the accused found herself in. Accused number 1. And my Lord, in trying to get medical treatment for this child, psychological or psychiatric treatment, in a country in which I pray court takes judicial notice, the fact that we have a very weak mental health service provision, the accused commenced on a series of actions which, as the count says, were punishment. Punishment in the sense that it was retribution for actions that the boy had done. And my Lord, in light of the fact that there was a social worker, a probation service worker who could have and perhaps should have been involved in this matter, my Lord, the accused accepts. She crossed a line and finds herself here in these circumstances, very regrettable circumstances. My Lord, with regards to accused number 2, as the prosecution have rightly opened, he is the husband of accused number 1. Conduct which is complained of was generally done, essentially done by the first accused. My Lord, the second accused was aware. Aware, yes ma'am, doesn't deny that. And my Lord, he too did not take this matter to the probation service. He too did not try to find another way around managing this difficult conduct. And my Lord, the basis essentially of the charge against him is one of omission. Lord, that was the point that I wished to highlight around the circumstances of the case for count 1 and count 2. My Lord, for counts 3 to 6, again, it's not denied that work permits expired and special permits or special passes had not yet been obtained. My Lord, the basis of the plea is essentially in circumstances of what could have been strict liability. The accused were present and the accused were working in the country. And my Lord, in mitigation, I will address the fact that they did try and they had hoped to renew. My Lord, an application had been made. Immigration didn't seem to have record of that application, but my Lord, our understanding of those offences are that they're strict liability offences. My Lord, in mitigation, we wish to adopt the points we put out, that are set out in paragraph 6. Page 6, and it's also paragraph 6.2. And my Lord, by way of highlighting, we wish to point out first and foremost the absence of any of the seriously aggravating features that sometimes are present in cases such as this one. My Lord, this wasn't a case of gratuitous cruelty. My Lord, it wasn't a case of sadism or some form of perverted gratification. My Lord, the accused persons in our submission found themselves in a very difficult situation, which they didn't handle in the way they could or should have. Secondly, my Lord, and again not casting blame away from themselves, it is our humble submission that this honorable court ought to take into account what can only be described as a systemic failure. A systemic failure that landed two young Americans, which was material as non-Ugandans, without social ties in this country, without previous parenting experience, to have not one, not two, but 3 children under their foster care, 2 of whom, my Lord, as I set out in paragraph 6.2, had underlying medical conditions case of the victim, my Lord, we submit a psychiatric condition. My Lord, I should add that this was all compounded by the fact that the accused persons also suffer from a rare medical condition themselves, which renders them physically disabled to a degree, or varying degrees. My Lord, the condition is called Ehlers-Danlos. Ehlers, E-H-L-E-R-S. Ehlers-Danlos, with a hyphen. Danlos is D-A-N-L-O-S syndrome. And it's an inherited disorder that affects connective tissue in the body. My Lord, in their own limited circumstances, they were tasked with caring for 3 children who also had limited and challenging circumstances. My Lord, they would account for their failure to take this matter up with the probation service in the way that they should have. With their love for these children, my Lord, they loved and still love these children. And my Lord, this misapplied love, if I may call it that, lands them here and my Lord has put them to a great punishment. A great punishment. Punishment number 1, my Lord, is on account of their medical condition, they cannot have children of their own, which is why they try to adopt. My Lord, with the circumstances, the regrettable circumstances that occurred, and with this conviction, my Lord, it is not likely that they will ever be able to adopt foster children here or anywhere else in the world. My Lord, I do not think it would be facetious for me to say it's essentially a life sentence. They wanted to have children, they wanted to look after children, but they will not be able to look after children. And they're biologically condemned not to have children of their own. And secondly, aside from the loss of their good character, the fact that they had no convictions prior to this, my Lord, it is now a situation where they will have to deal with this for the rest of their lives, reputationally as well. This will injure their ability to work, and they're only 33 and 32 respectively, with a full life expectancy, with an internet that never forgets. My Lord, lastly, but by no means of least importance, is the fact that the children that were being cared for, aside from the victim, but including the victim, perhaps I should say, have also all had a situation where they had hoped that their circumstances would change. They had lived in a home where they were given love and care and material assistance in a manner in which they had not, by reason of their parental circumstances, had not been able to afford. And Lord, they have lost those children. And indeed, the circumstances of those children are innocent, entirely innocent. They find themselves where they are, how they are. It is a humble submission, my Lord, that the sentence, and I should have mentioned, my Lord, it's in the material facts of the case, that upon arrest, both accused spent in excess of 103 days. Total, my Lord, of 103. My Lord, they were detained in December and released in March. But my Lord, it's in 104 days, yes, my Lord, 104 days. 3
months and 14 days.
So it's 3 months and 14 days in custody. A circumstance that aggravated both their conditions, perhaps accused number one more than accused number two. Indeed, my Lord, accused number two's situation with her foot has been aggravated to the extent, my Lord, I hand up a clinical report from Ruby Hospital. A1, my Lord. We're saying A1 was affected more than A2. My Lord, she has a fracture to her 5th metatarsal. I believe that's a toe. But my Lord, because of the underlying condition, your Lordship will see in that report her ankle, intertarsal, etc. I don't wish to mangle those medical terms, but her ankle is involved. It's not healing. She most likely will require the 10th surgery in her life. She's already had 9 for various joints and parts of the body that have been affected. My Lord, in conclusion, we commend the sentence. We commend the proposed sentences in the plea bargain agreement. submit that they meet justice, they meet the public interest in this matter, and most especially, my Lord, meet the interests of the victim insofar as there is an order, proposed order of compensation. Which, my Lord, will be funded today upon your Lordship's direction. And my Lord, we would pray that this Honourable Court assist in guiding on the nomination of the trustee or trustees for the victim, with the DPP working perhaps with the public trustee, the Administrator General, in order to ensure that the victim gets the full benefit of the money which is to be paid into the Recovery Management Fund. Because, my Lord, he does need it, and it would be very useful in improving his life and welfare. My Lord, unless there's anything which I can assist the court with, those are my submissions.
Mu nsala ye omulamuzi Omuhanja akkiriziganyiza ne bannamateeka abavunaanwa nti kituufu tewali nteekateeka nnungamu erabirira abaana batalina mwasirizi, wabula nasaalidde mukyala Spencer ekibonerezo ky'engasso obukadde 3.5, so nga bba Spencer owa okusasula akakadde 1.5 olw'okulagajjalira omwana.
I have considered the aggravating and the mitigating factors as contained on pages 6 to 7 of the plea bargain agreement, and also as submitted before me this morning. I agree with counsel for the accused persons, that all convicts now, that there is a systemic problem where there seems to be no mechanisms to take care of unfortunate children like the victim in this case. That's why the victim found himself in the hands of the accused persons who are non-citizens of Uganda and also suffering from ill health. The child was in need of help and support, having lost his father and having been abandoned by his own mother, with no known relative willing to support him. Unfortunately, the accused persons failed to manage his peculiar behaviors, and that's why we are here this morning. I have considered the sentence which has been agreed upon between the prosecution, the accused persons, and their counsel, which is contained on pages 3 to 4 of the plea bargain agreement, and I believe that the same meets the ends of justice of this matter. I accordingly adopt the sentence, and I sentence the convicts as follows. The first convict, who has been convicted of counts 1, 3, and 5. On the first count, Miss Mackenzie, I sentence you to a fine. You're going to pay a fine of 3,360,000 Uganda shillings, and in default thereof, you shall serve a sentence of 2 years imprisonment. And if you have to serve the 2 years imprisonment in default of paying a fine, the months that you have spent on remand, before you go to bail, the 3 months and the 14 days shall be deducted. On the third count, I sentence you to serve a prison term of 2 months, but you already served, or you already spent on remand 3 months and 14 days. Therefore, you will not serve this sentence, and you're therefore discharged on this count unless you're held on other lawful charges. The last count, which was count 5, again you are also sentenced to 2 months imprisonment. I have considered the time that you spent on remand, the 3 months and the 14 days, and because of that, you will not serve this sentence. You've already served, and you are discharged unless you're held on other lawful charges. I come to you, Mr. Scott, for the 3 counts, that is count 2, 4, and 6. For that second count, for the second count, you are sentenced to a fine of 1,500,000 shillings. And in default thereof, you will serve a sentence of 6 months in prison. But if you default to pay a fine and you're going to serve this period of imprisonment, then the 3 months and the 14 days that you spent on remand shall be removed, and you serve less than 3 months and 14 days. On count 4, you are sentenced to a period of 2 months imprisonment, and considering that you already spent 3 months and 14 days on remand, you have already served that sentence and you are accordingly discharged unless you are held on other lawful charges. And lastly, on count 6, you're also sentenced to 2 months imprisonment, and considering the period of 3 months and 14 days that you already spent on remand, you are discharged unless you're held on other lawful charges.
K'omuhanja era balagidde okuliyirira omwana obukadde bwa kuno 10 okumuyambako mu bulamu bwe.
You're also supposed to compensate this child, and each one of you shall compensate this child to the tune of 50 million Uganda shillings, which makes it a total of 100 million Uganda shillings. That money shall be deposited on the account which is held at Bank of Uganda. It is the ODPP Asset Recovery Management Fund account, and the details of it are account number 0033 0148 50 and 2. That is in the interim, pending the appointment of a trustee who will manage these funds for the victim. And given the circumstances of this victim, who seems to have no family, in order to ensure that the funds are properly managed for the benefit of the child, I order that the office of the DPP shall work with the public trustee, who is the Administrator General, at least within 3 months from the date of this order, to agree on how this money should be managed for the benefit of the child. And this compensation should be paid today, or not later than today.
Mackenzie Leigh Spencer ne Nicholas Spencer bano nga bajja mu ggwanga lya Uganda mu mwaka gwa 2017 okufuna abaana. Bakwatibwa ng'ennaku z'omwezi 8 omwezi gw'12 omwaka 2022 oluvannyuma lw'omukozi waabwe okuba wawabira ku poliisi ku by'okutulugunya n'okulagajjalira omwana.